Welcome and thank you for standing by. We'd like to inform all participants your lines will be listen only until the question and answer session. At that time, for questions from the phone, you may press star 1 on your touch-tone phone. Today's conference is being recorded. If you have any objections, you may disconnect at this time. And now I'll turn today's meeting over to Bill Meyer. Thank you. You may begin.
Thank you. Welcome to Session 4 of OCSE's Intergovernmental Forms Training. I am Bill Meyer, an OCSE Program Specialist, and I will be the moderator for today's session. Debbie Ward from OCSE's Division of Policy and Training and Jeanette Savoy from the Center for the Support of Families will provide our training. As in the previous sessions, you will have opportunities to ask questions over the phone, and you can submit written questions in the Q&A section of the web presentation. We have a panel of OCSE staff on hand to assist in responding to your questions. If we do not get to your question today, OCSE will respond to you as soon as possible. OCSE is currently working on responses to a number of questions from the previous training sessions. After the training session, you may continue to submit questions on the intergovernmental forms to ocse.dpt@acf.hhs.gov. This address is available on the final slide of each of the 4 training sessions. This is the 4th and final training session on the intergovernmental forms. Let's review what we have covered so far. In Session 1, we covered the objective of the training course, background, the general changes that were made across forms, and the first 4 individual forms: the Child Support Agency Confidential Information Form, Personal Information Form for UFSA Section 311, the Transmittal Number 1 Initial Request, and the Transmittal Number 1 Initial Request Acknowledgement. We also covered implementation timeframes. In Session 2, we covered the Transmittal Number 2 Subsequent Actions, Transmittal Number 3 Request for Assistance Discovery, the Letter of Transmittal Requesting Registration, and the Uniform Support Petition. In Session 3, we covered 2 additional forms: the General Testimony and the Request for Change of Support Payment Location pursuant to UFSA Section 319. As noted in Session 3, OCSE is planning to issue further guidance on payment processing. Today, we will finish our discussion of the individual forms covering the Notice of Determination of Controlling Order, the Child Support Locate Request, and the Declaration in Support of Establishing Parentage. We will also discuss a forms matrix that OCSE is developing to help in guidance on the distribution of federal forms in intergovernmental cases. We will also have some scenarios to discuss, implementation timeframes, resources, and training wrap-up. Now I'd like to turn it over to Debbie to start today's training.
Thanks, Bill. Let's get started with the Notice of Determination of Controlling Order form. So on slide 1 of the Notice of Determination of Controlling Order, UFSA includes provisions to ensure that there is only one valid order between the parties that control the amount of current support due. The need for a determination of controlling order, or DCO, should be rare, since there are very few cases where there are still multiple valid orders with a current support obligation. However, OCSE decided to keep this form. This form provides a standard format for notifying courts and administrating agencies and other jurisdictions that a controlling determination has been completed by your tribunal. This is not a request to make a DCO. UFSA Section 207 requires the party obtaining the DCO to notify each tribunal that issued or registered an earlier child support order of the tribunal's DCO within 30 days of the determination's issuance. The actual determination will likely be in a state-specific format, for example, an order or a form which may be attached to this notice. The form may also be used to inform the 4D agency, the obligor, and the obligee of both the controlling order and the consolidated arrears accrued under the multiple orders. Only minor changes were made to the old form. The header was changed to add a date of notice to the form to capture the date the notice was issued. The rest of the header was changed to be consistent across all governmental forms, as we've discussed in previous sessions. On slide 2 of the form, as we stated earlier, there are minor changes, and because it is increasingly rare that there are multiple orders in a case, in item 1 we reduced the number of potential orders listed from 5 to 3. Item 2 now has checkboxes to indicate the decision made by the tribunal. Item 3 provides a place to note the state that issued the controlling order and explains that that state's law governs, and that is permanently governs, the duration of the support obligation. Even if the controlling order is subsequently modified, according to a OCSE, the duration of the initial controlling order, in this case, as indicated on this form, continues to govern duration of any modified order. As you see on slide 3, item 6 is formatted a little differently than on the old form, but provides the same information regarding who has been sent this notice. Now I'm going to turn it over to Jeanette, who's going to go over the child support locate request.
Thanks, Debbie, and welcome everyone to our final forms training session. The child support locate request form is used between child support agencies to request locate information on individuals, of course, for child support purposes. The form is used to make the request to another state only when a SISNET agreement is not in place. Most states have these agreements in place, so this form will not be needed often. The requesting agency completes as much information as it has available and sends the form to the other state. A state may also use this locate form to request locate information from a tribe, a foreign reciprocating country called an FRC, or a Hague Convention country, when there are no other prescribed locate forms for that specific entity. Before using this form to send a locate request to a tribe, inquire with the tribe about their preferences. And similarly, before using this form to send a locate request to an FRC or a Hague Convention country, check the caseworker-specific guide for the FRCs, which is on the OCSE website, or the Hague profile for Hague Convention countries for information about that country's preferences. We did change the name of the form from Locate Data Sheet to Child Support Locate Request just to help clarify the purpose of the form. You can see now on slide 2 for this form that this revised form is divided into 4 sections. Section 1 identifies the person for whom you are requesting locate information. The checkboxes for non-custodial parent and custodial parent information were changed to the parent who owes or may owe support and the parent who is owed support. A checkbox was added for a caretaker who is owed support also. Under Section 1, the group advised OCSE that much of the demographic information on the old locate data sheet was not needed when making or responding to locate requests. For this reason, most demographic questions have been deleted, leaving only information about name, Social Security number, date of birth, and the possibly dangerous indicator. Section 2, other pertinent information, gives you a space to enter information that might be useful in locating the individual, especially if sending this form to a tribe or foreign country. This might include things like the physical description, nationality, passport, place of birth, gender, etc. On this next slide 3, Section 4 is the contact information for the requesting caseworker. And as we previously discussed, providing direct contact information will facilitate better communication. Now I'll turn it back over to Bill for questions.
Thank you, Jeanette. And we'll take just a few minutes here to see if anyone has any questions they'd like to ask about these 2 forms that we've reviewed. So if we could open the lines briefly.
Thank you. At this time, to ask a question, press star 1, please. Please unmute your line and record your name to be introduced. Again, for questions or comments, press star 1. If you'd like to withdraw the request at any time, you may press star 2. Thank you. One moment, please, for your first question.
Thank you. So no questions so far from anyone on those two forms?
We do have a question in queue. As a reminder for others, it's again *1. We do have Karen Grant. Your line is open, and please identify the state you're calling from.
Hi, I'm calling from Michigan. Thank you for taking my call. I have a question about a request to a tribe for a locate. I have a situation where I haven't been able to locate somebody. They may be living on a tribe. Is this a situation where I would use this? I would call the tribe and ask what they would require for doing a search or a locate request?
Yes, I think that's exactly what you should do is call the tribe, ask if they will accept that locate request form.
Okay, and can I use this now? I know we're in Michigan, we're not set up yet to use the forms, but could I just make a copy of this and use it?
Yes, the forms are all valid now.
Sure. Okay, thank you very much.
Thank you, and we're showing no further questions at this time.
Okay. If there are no further questions on those two forms, I'd like to turn it over to Debbie to talk about the Declaration in Support of Establishing Parentage.
Thanks, Bill. On slide 1, the first change is the name of the form that you'll notice. The form was previously named the Affidavit in Support of Establishing Paternity and is now a Declaration in Support of Establishing Parentage. We did this because we changed the form itself to a declaration instead of an affidavit, since UFSA 2008 no longer requires a verified petition. We also changed to use parentage instead of paternity. The main reason for that change, the main reasons are there's two, really. To conform with UFSA terminology, which has always included a legal action authorizing the responding tribunal to determine parentage of a child. And the second reason was to encompass all types of families. So parentage means the establishment of the parent-child relationship and includes maternity and or paternity, while federal child support law requires states to have laws to establish paternity. In appropriate cases, several states also have state laws that establish parentage for same-sex couples and for intended parents through assisted reproduction. Since UFSA 2008 is the law in every state, and states have a wide variety of parentage establishment laws, the Intergovernmental Forms now uses the term parentage. The Declaration in Support of Establishing Parentage supplements the Uniform Support Petition when parentage is at issue in an intergovernmental case. As you may recall, we reviewed the Uniform Support Petition in Session 2. So a petitioner who may be a person claiming that the respondent is the child's parent or a person claiming to be the child's parent must use the declaration to provide evidence to the responding jurisdiction. As with the previous form, a separate form is required for each child needing parentage establishment. This is necessary since the circumstances surrounding conception and birth will differ unless the children were born at the same time, for example, twins. We added a sentence to the instruction that says a person should complete the form to the extent that he or she has the information. If the person does not have the requested information, they may leave that response blank. If the petitioner is a caretaker, he or she should fill out the form to the best of his or her ability. As you will see when we get into the form, we revise the form so that the caretaker has the option to check not applicable to certain questions. So basically this form was changed to remove most personal identifiable information, or PII, and require that a personal information form for UFSA Section 311 be attached. We changed the terminology to be gender neutral. We ensured that an individual who seeks to establish his or her parentage can also use the form. And lastly, we revised the questions to determine whether any individual is the child's presumed parent under state law. As you can see on the screen, the statement, "Do not complete this form if any person has been legally determined to be the parent of the child," has been added to the form's header for clarification. A legal determination of parentage is determined under state law, and it may include a divorce decree, tribunal order, or an adoption order. A voluntary acknowledgement of paternity or parentage that has not been rescinded also legally establishes parentage. The rest of the header was changed to be consistent across all the intergovernmental forms, as we've discussed in session one. Since a form cannot be designed to cover all the information that may be needed in a complex case, we have updated the comments box in the instructions to indicate that the responding jurisdiction may require additional information, as is the case with most of our forms. So on slide 2, section 1 starts with the declaration that is to be completed by the petitioner. Because of changes to USC 2008, we changed the declaration to what you see on the screen. So it's I, your legal name, declare under penalty of perjury. While revising the form, we changed many of the questions for clarity and to provide more information, though the intent of the questions is much the same as it was on the old form. Item 1, the relationship of the petitioner to the child is established with a series of new checkboxes, which, as you can see, include the petitioner is the biological parent of the child, and for this question, the parent must check the gender box. The petitioner is the non-biological parent of the child. Again, a selection of gender is required. A non-biological parent may be the same-sex spouse or partner of a parent or the intended parent through assisted reproduction. There is an other checkbox if the other two checkboxes do not apply. In this case, the petitioner would explain his or her relationship to the child in Section 4. Next, you provide information about the child for whom you are seeking to establish parentage. The information about the child is essentially as it was in the previous form, with two exceptions. First, there's a checkbox to indicate whether or not the child's birth certificate is attached. If it is not attached, explain this in Section 4. And second, the mother's maiden name was removed. Item 2 determines if the respondent is the biological mother or father, the parent, of the child, or if the respondent is a non-biological parent of the child. As we mentioned above, this could be a same-sex spouse or partner of a parent or the intended parent of a child conceived through assisted reproduction. Item 3 has changed somewhat to include the name of the birth mother and the name of the person with whom the birth mother had sexual intercourse that resulted in the conception of the child. One of the names should be the full legal name of the birth mother, unless this is not applicable. For example, if the child was conceived using assisted reproduction. In these situations, you must add the pertinent information regarding conception in Section 4. So we're on slide 3 of the Declaration in support of establishing parentage. Item 4 is intended to identify whether there is a presumed parent under state law. That individual may be the respondent or another person. The law of the responding state will govern whether and how a presumption of parentage is created. The more common grounds are covered by the questions in this section. The responding state may require additional information, and if you need space to provide more information, use Section 4. So item 4A indicates a birth during the mother's marriage or within 300 days after the marriage legally ended. Every state has a presumption of parentage for a child conceived or born during a marriage. In most states, the spouse or former spouse of the birth mother is the presumed parent of the child until the presumption is rebutted. The revised form includes dates of marriage and divorce or legal separation, as well as the name of the tribunal that issued the order legally ending the marriage. And item 4B indicates whether a person acted as or represented himself or herself to be the child's parent. This reflects the holding out presumption that exists in many states. Item 4C indicates whether a court or a 4D agency completed genetic testing to determine the biological parent of the child. State laws vary on the percentage of probability of parentage that creates a presumption. If genetic testing was conducted, include the probability of parentage from the test and attach the results. Notice that for all three of these questions, if the individual named is not the respondent named in this declaration, you must provide the individual's name, address, gender, and explain in the space below the relevant question why the individual is not the child's parent. Okay, so we're on slide 4 of the declaration, and item 5 asks whether someone other than the birth mother is named on the child's birth certificate. If yes, provide the name, address, and gender of the individual. This question was reworded to encompass all types of families. All states have laws that address if a child is born outside of marriage. The father's name may be added to the birth certificate only if there has been a legal determination of parentage, either by order from a tribunal or by a voluntary acknowledgement of parentage. If you check yes and the individual is not the respondent, state law and program policy will determine how to proceed given the specific facts detailed in other parts of the declaration. Item 6 asks whether any person has completed a voluntary acknowledgement of parentage for the child that has been rescinded. So if this is yes, attach a copy of the acknowledgement and the rescission form. Provide the name and address, gender of the individual or individuals who signed and later rescinded the acknowledgement. So as we discussed earlier, if there's a signed voluntary acknowledgement of parentage that has not been rescinded, you should not be completing this form. You already have a legal determination of parentage. Additionally, Section 315 of UIFSA states that a party whose parentage of a child has been previously determined by or pursuant to law may not plead parentage as a defense to a proceeding under UIFSA. So now we're on slide 5, and Section 2 must be completed by the petitioner. The petitioner is either asserting that the respondent is the parent of the child named in the related petition by checking item 1, or asserting that he or she is the parent of the child and is seeking to establish a legal relationship to the child by checking item 2 on the next slide. Check only one box, item 1 or item 2. If the petitioner checks the first checkbox, he or she will answer the questions A through N as shown on this slide. If the petitioner is the caretaker, there may be some questions that cannot be answered. The case should not be rejected just because some of the questions have not been answered. The information is essentially the same for both items 1 and item 2 as it was on the old form, though some of the items have been eliminated. The ones that were eliminated were, I have told welfare officials that he is the father of the child. The second one is he is or I am named as the father on the birth certificate. The third one, he signed or I signed an acknowledgement of paternity before an acknowledgement became a legal finding of paternity under state law. And the last one was they're a witness to my relationship with him or with the child's mother. So this is the second checkbox. So if the petitioner asserts he or she is the parent of the named child, you answer A through L. Again, the questions are essentially the same as they were on the old form, with the exception of what we discussed on the previous slide. Both sets of questions were changed to be gender neutral. So we're on slide 7 now of the Declaration in Support of Establishing Parentage. Section 3 is to be completed by the birth mother only and is similar to Section 2 of the old form. This section asks if the birth mother had sexual intercourse with a man other than the person named as the respondent during the 30 days before or 30 days after the child was conceived. If the answer is yes, she must provide the information on the other man or men and indicate, if applicable, why she does not believe the other man or men are the child's biological parent. Jurisdictions differ on how to handle a case when the mother had sexual intercourse with more than one partner during the time frame. Some states will proceed against the most likely alleged father first, moving on to the next alleged father only if the first individual is excluded through genetic testing. Other states will proceed against all alleged fathers simultaneously, and still others will provide notice to all alleged fathers, even if pursuing the most likely individual initially. It's important that the mother provide as much detail and information as possible to allow the responding jurisdiction to proceed according to its laws and procedures. Section 4, Other Pertinent Information, is used to provide detailed explanation for items in Sections 1, 2, or 3. If additional space is needed, then you would check the continued on attached sheets incorporated by reference and attach the additional information or documents. Section 5, Declaration, has changed to reflect that USC 2008 no longer requires a verified petition. As we've discussed in previous sessions, the petitioner seeking to establish parentage must sign under penalty of perjury and date at the bottom of the page. By this signature, the individual is confirming that the information and facts provided in the declaration are true to the best of his or her belief. Now I'm going to turn it over to Bill for questions.
Thank you, Debbie. We'd like to open the lines to see if anyone has any questions regarding the Declaration in Support of Establishing Parentage.
Thank you. Again, for questions or comments, press star 1. Please unmute your line and record your name only to be introduced. For questions or comments, press star 1. If you'd like to withdraw the request, you may press star 2. Thank you. Please stand by for your first question.
And as a reminder, you can submit questions in the Q&A section of the web presentation as well.
Okay, we do have a couple questions in queue. One moment, please.
Thank you.
Thank you. We do have Eleanor Tate. Your line is open, and please identify the state you're calling from.
Good afternoon. I'm Eleanor Tate. I'm with the state of South Carolina. My first question is on page 1, Declaration in Support of Establishing Parentage. Do not complete this form if there is an order or signed voluntary acknowledgement of parentage. Sometimes in South Carolina, the judges will still allow a genetic test if the alleged father asks for one. So if I'm sending this form to another state and I have a voluntary acknowledgement of parentage, do I need to attach that to the packet? Even though in most other states, genetic tests may or may not be, they may or may not allow a genetic test. South Carolina sometimes will allow a genetic test, even with the voluntary acknowledgement.
I think what we heard was that if you have that voluntary acknowledgement, you wouldn't send this form initially. If the judge makes another determination down the road, then I think you have to proceed at that time with what the judge says. But initially, since you have that acknowledgement, you wouldn't send the declaration.
You wouldn't have to send this. Okay. And
Bill, I just want to add something here.
Sure.
So if that acknowledgement was done in, are you South Carolina?
Yeah.
Then that action of trying to disestablish can only be done in South Carolina. You can't ask another state to disestablish paternity that was done in your state.
Right. Okay, that makes sense. And then the second question is on page 2 of the same form. Number 3, the child was conceived as a result of sexual intercourse between, and then it's got legal name and then the second blank. Now, if this is a same-sex party that we're sending this paperwork on, do we put those parties' names on both of these lines? So if it's 2 females or 2 males, I mean, that's dumb. What I'm asking is the legal name, it would be the person that the female says she had sex with. That's where you would put the legal name on that first line?
I think it's only if applicable. So if it's not applicable, you wouldn't need to complete that. So in other words, I think that line you're referring to has to do with the person that the petitioner is alleging is the parent.
Right.
And so again, if it's if they had sexual intercourse with that person, then they would put that there.
So the legal name would be okay. So if it's a male and a female, the first blank would be the female's name. The second blank would be the male's name. If this were a caretaker filling out this form, does that make sense?
I'm not following entirely. Jeanette, can you help me out here?
I would say that this line only applies when you have what we would call the traditional mother and father.
Right.
So whoever the birth mother is, if she had intercourse with a man that produced this baby, you fill out this line. If that is not the case, this line doesn't get filled out.
Okay. So if it is a traditional mother and male and female, is the female the legal name and the alleged male, you put his name on the second line?
Yes.
Okay. All right.
Thanks, Jeanette.
Hi, this is Ann Miller in OCSE. I would just add that if it's not a male-female situation as described, then you should describe the pertinent information about that relationship in Section 4.
Yes, thanks, Ann.
Thank you. Next question is Paulita Harris. Your line is open, and please identify the state you're calling from.
Paulita Harris from Virginia. Can this declaration be used by a state agency that's the caretaker, i.e. a foster care unit, when paternity has not been established, or we have no proof that paternity has been established?
That's a good question. Jeanette or Ann?
Well, I would say yes. You still have to go through that process. You may not have the answer to many of the questions.
Right.
So this is Yvette Riddick, and that is a good question that hasn't been answered before. So I'm not going to give you an official answer, but my instinct is that yes, I don't see why you could not use that form. And if it meets your needs and it's applicable to your situation, then I certainly don't think that there's any problem with using it.
Okay, thank you.
Thank you. Again, for questions or comments, press *1, please. Next question is Mary Ellen Emery. Your line is open, and please identify the state you're calling from.
Thank you. I'm calling from the state of Michigan, and I have a question about slides 5 and 6, specifically the question that asks about payment of abortion expenses. We're talking about child support, so I don't understand the relevancy, and I think would that not be overly intrusive, if not offensive, and could you explain how that is relevant?
I think on here, go ahead.
That question has always been on the form, and I think it's just relevant in terms of someone offering to pay for abortion expenses is often the other parent.
So I guess that's not a reimbursed expense, and I mean,
well, abortion obviously hasn't happened because the child was born.
Right. And you're just looking for evidence that the party named is actually the parent, the father, oftentimes. As if it were testimony in a court hearing or something like that.
I just thought that, there could be other, I understand medical needs and birth-related expenses, but I just feel that might be overly intrusive and offensive and probably not go far to relevancy, if at all, and maybe only inflammatory, but I guess there are reasons for it to be there. I appreciate your response.
Thank you.
And as I said, it's not a new question. It's been on the form.
The forms are being revised, so I thought maybe everything would be looked at.
Yeah, I appreciate that. I don't believe we got any feedback of that nature.
Sure.
So this is Yvette Riddick, and so we're sitting here in central office, and we understand your comment, but it's been on the forums for a really, really long time. But I also want to indicate that if it bothers you and you do have the opportunity, these forms will go through the Paper Reduction Act process again, probably 2 years from now, and we would encourage you to submit a comment regarding that, and we will certainly review your comment and consider it when we're revising the forms.
Thank you.
Thank you. And at this time, we're showing no further questions.
I did have a couple of questions, I think, in the Q&A, and I'll just read the first one. If a Children and Youth Agency is filing for support and completes the declaration in support of acknowledging paternity, actually parentage, must the responding state accept this and not reject it? You want to take a shot at that, Jeanette?
Well, I think that's partly why we put that line in there that said just because the form is not totally complete, it shouldn't be rejected. I do know when I was with Colorado, this is something that we'd hear now and again, that states would reject the form. The unfortunate thing, if that's the case, they're going to reject the whole case and the child will never get paternity. So it certainly would be my hope that they wouldn't reject it. I don't know if any Ann or Yvette would have a comment.
So, Jeanette, this is Yvette, and I agree with you on that point.
And that actually is the only other question we have. We just had a comment on the previous question that the abortion expenses comes to play with the admission of parentage, not with regard to paying. It is the act of offering that is looked at. So I think we've already addressed that as well. Are there any other questions on the telephone about the declaration in support of establishing parentage?
We're currently showing no questions.
Okay. Well, I think we can move on then. I'm going to turn it back over to Jeanette to talk a little bit about a forms matrix.
Thank you, Bill. So you should have received this as a handout, and you'll notice that it's still marked as a draft. The matrix will be finalized before it's published on the OCSE website. The Intergovernmental Forms Matrix that you see on this slide is a tool for caseworkers to use to determine what federally required forms or what federal forms are required for the action that they're requesting. The column on the left lists the type of action being requested and mirrors the actions on the transmittal number 1. And the column on the right lists the federal forms that must be included with that type of case. As you can see, there's not a row for establishing parentage only. This is due to the fact that under the Code of Federal Regulations, the state does have the option now of providing limited services for paternity-only services in intrastate cases to any applicant who requests such services. It does not grant this option in intergovernmental cases. The column on the right lists the federal forms that are required for an intergovernmental action. Establishing paternity and support is the case on this slide. This column also indicates what actions to mark on the transmittal, which you also should have received as a handout for this session. So you can see there under Federal Forms, where it's on number 1, it says check and gives you the items. Now on page 2 of the forms matrix, you see some additional rows. The actual document is only 1 page. We've just broken it down to be able to see it on the slides. In each row, you might be requesting only some of the actions. For example, you might ask a responding state to establish current support but not retroactive support. In another type of case, if you're requesting medical support only, current support and retroactive support would not be applicable. But the forms don't really change. I want to draw your attention to the second and third rows. In these actions, enforcement and or modification of the responding state's order is being requested, and you're checking an action under item 3 on the transmittal number 1. Remember that action number 3 on the transmittal 1 only applies if the order was issuing by the responding state. When I was part of the Colorado Central Registry, we often saw this marked, even though the order was issued by a different state. So it was a very common error. And of course, selecting the correct action on the transmittal number 1, and of course, including all the required forms, helps to ensure the success of your case. Now on page 3 of the forms matrix, you see the actions related to requesting the responding state enforce and or modify another state's order. Notice that these actions do not require the personal information form for UFSA 311, as the necessary information is included on the letter of transmittal requesting registration. Remember that this matrix only covers the required federal forms. Of course, there are other documents that may be necessary in most cases. These might include certified copies of an order, a payment history or arrears calculation, and birth certificates or birth records. Of course, supporting financial documents such as pay stubs and tax records may also be necessary in cases of establishment or modification. Now I'd like to turn it over to Bill for questions.
Thank you, Jeanette. We'd like to open up the lines again briefly to see if there are any questions about the forms matrix.
Thank you again. For questions or comments, press star 1. Please unmute your line and record your name. To withdraw the request, you may press star 2. Again, for questions or comments, press star 1, please.
So we do hope that that matrix is fairly straightforward and it's still in draft, but if you have any questions about it now, we'd like to hear from you.
Thank you again. For questions or comments, press star 1. We do have a question in queue. One moment, please.
Thanks.
All right, thank you. We have a question from Melissa Moss. Your line is open, and please identify your state.
Yes, I'm calling from Michigan. And I'm calling in regards to the personal information form, the UFSA 311. Now, is that just for tribunal cases, or is it to be filed with all cases?
So that form gets filed basically with anything that's going to go before a tribunal. Anytime you have a establishment or modification action. That
okay, so it's only tribunal cases, though? Like for the tribes or any case period?
Oh, no. Tribunal meaning a court. Okay.
Court. Okay. Okay.
Yeah. Court or tribunal, and in all states they don't use court. Don't use courts in all states. So anything that needs modification, it needs a uniform support petition, a general testimony, or I'm forgetting one. Anything that requests modification or establishment needs that form, along with the Child Support Agency confidential information form.
So that confidentiality form has to be attached to every case as well?
The one that's called the Child Support Agency confidential information form, yes, that's the form that the responding agency is going to use to build their case.
Okay, all right, thank you.
Right, and the UFSA Section 311, those are the required data elements or demographic information that is specifically required by UIFSA for a UIFSA action.
Currently, we're showing no questions. Again, for questions or comments, press star 1, please.
Okay, we'll give it just another moment. I've got no questions in the Q&A either, so I think we'll move forward. We do have some scenarios to go through today to talk about different situations and what forms might be needed when. This will be a way of reviewing what we've learned about the new forms. We're going to assume in all scenarios that the obligee has an open 4D case in the state in which he or she resides and that the obligor is not paying support. The caseworker is preparing an intergovernmental case. In scenario 1, the father has custody of the child and they live in Michigan. Mom lives in Colorado. A Colorado divorce orders mom to pay dad $200 per month. Dad is on TANF in Michigan and the worker is preparing a case to send to Colorado. What action should be requested on the transmittal number 1?
So I want to give you just a moment to look at the scenario and your forms matrix or your transmittal and decide upon the answer, and then I'll cover the response. So on the transmittal number 1, action 3A should be marked. Whoops, that's the right one. Action 3A should be marked, requesting enforcement of the responding tribunal's order.
Thank you, Jeanette. What federal forms must be included in that referral?
Michelle, would you bring in the next question, please? Thank you. So in this case, there are only 2 federal forms that must be included. The Child Support Enforcement Transmittal Number 1, Initial Request, and, as we just talked about with that last question, the Child Support Agency Confidential Information Form. And then one more question, Michelle?
Are there other documents that should be included or would be helpful?
Well, we don't have other documents on the matrix. It covers only the federal forms. It is certainly important for you to think about what other documents you might need to include. In this case, a copy of the responding tribunal's order could be helpful, and certainly any payment information of which the responding agency may not be aware.
Thank you, Jeanette. And would like to open the lines again briefly just to see if anyone has any questions on this scenario. I know there have been a lot of questions about the Child Support Agency Confidential Information Form and the UIFSA 311 form, and hopefully here we kind of demonstrated some of that, the distinctions here and discussed.
Thank you. Again, for questions or comments, press star 1, please. All right, thank you. We do have a question from Eleanor Tate. Your line is open, and identify your state, please.
South Carolina.
Okay, hi.
Hi. Thank you guys for doing this training because I am so confused. I have been using the new forms, and I think I have been doing everything all wrong, so thank you guys so much. What I have been doing on the scenario that we just had was if the order was established in South Carolina and both parties were here when the order was established and the non-custodial parent moved to another state, I was submitting, and you tell me if I'm wrong, a transmittal 1, a registration statement, and the confidential statement. Am I correct?
So that's a little bit different scenario because in that one you're asking them to register your order rather than enforce their own order.
Right.
So you're almost correct. You also need the, tell me again what you're including?
The transmittal 1, a registration statement, and the Child Support Agency Confidential Information Form.
That really is, I believe, all the federal forms. Let me just make sure I'm looking at it right. As long as you're not asking them to modify, you're just asking them to enforce your own order. Yes, right. You're doing that correctly. Are you using the new letter of transmittal requesting registration?
Yes, I am using...
You're using the new forms?
Yes, letter of transmittal requesting registration, transmittal 1, and the confidential.
That's totally correct.
Okay, so on the scenario that we just had, NCP is in Michigan. The
scenario we just had, it's the responding state's order that they're going to enforce.
Okay, so that is different. All right. And, okay, so I'm not confused. I was right.
No, you're doing fine, it sounds like.
Now, I came in late on the call, so the notice of determining of controlling order. Can somebody just real briefly give me that information again? Give me that information because I missed all of that.
Well, we will have this published on the website fairly quickly, I think, so you can go on there and read the full description. Basically, it's a form that's going to be very rarely needed these days because it's very rare to have two orders that still control current support. So I think the best thing would be for you to wait until it's on the website and just go review it, but don't be too concerned about it.
Okay. And there weren't too many changes to that form, as I recall. Is that correct?
Right.
All right.
And Jeanette, this is Liza Lowe, just jumping in to reiterate what we'll probably say at the end of the call, but just all the resources are available on our website shortly, including the recording. So we will get the recording up as well, and you can listen to this again.
Sounds good.
So,
Thank you.
This is Yvette, and I think I just want to put a little bit more context in this just for some of the newer workers, because I keep hearing that we don't need to use this form again, but no one has really mentioned why. And I can tell you that when I was a caseworker back in the 70s, a lot of times, interstate didn't exist the way that it did, so people would move, and instead of carrying their order with them or processing it through in an interstate fashion as we do today, they would just start a new order. So if sometimes as a caseworker, I might get a new couple in town, and they would have 3 different child support orders, and they were from 3 different states if they had moved around a lot. So that would be a struggle for me to figure out what to do, and a lot of times we would have to consolidate those orders. And when UIFSA and more advanced regulations came about, we recognized that there was a methodology that had to happen in order to determine what the controlling order was in a situation where there were multiple orders. But now, since UIFSA has been in place for as long as it has, that problem doesn't exist half as much or even hardly at all as it used to. So we in the child support community hope that that's not happening too much anymore. That is, multiple orders on the same case.
Thanks, Yvette. That was a good idea.
Yes, thank you.
Thank you. Again, for questions or comments from the phone, it's *1, please. Next, we do have Laura Schlegel. Your line is open, and please identify your state.
Pennsylvania.
Hello.
Hi. We have a question. Is 3A checked because we're requesting, is it a direct pay order in Colorado and we want it enforced through the child support office? Is that why 3A is checked, or is 3A always checked? Because we used to, for the original forms, we would select a redirection of payment for this. So we're kind of confused why 3E wouldn't be selected to change the entity of who's supposed to receive the funds.
Okay, so that's been a long-standing confusion with redirect. We actually took that off the transmittal one. So if you are asking the responding state to enforce the order for you on your behalf, open an intergovernmental case, then you check 3A. The 3E is if you have a new payee. So there's a new caretaker or the child is in foster care. So the money is no longer due to the original payee. There is still the just forward payment option. It's now done on the transmittal 3. And in that case, you're just asking them to forward you whatever payments they get, but there is no intergovernmental case. Does that help?
I think we're still a little confused. So if there's, like in this situation, if there's a Colorado order in place, it's through the child support office, and all we want to do is have Colorado send the payments to us, which one are we supposed to select?
So you don't want Colorado to enforce the order?
Well, I'm assuming they're already enforcing it. It's in their child support office, like it might be a local case in Colorado. And the plaintiff has moved to Pennsylvania, and we just want those payments to come through so that, she might be on TANF or something. And we just want the payments. They'll continue to enforce it, I'm assuming, but they'll just send us the payments.
Right, but you're sort of asking them to enforce too. In other words, if payments stop, the person changed jobs or whatever, you want them to enforce and send the money to you. So I'm thinking you would use transmittal number 1 to do that.
Okay, and just the checking 3A will get that done?
Yes.
Then what exactly do I need to use the transmittal 3 for again?
That's when it might be, the best scenario is it's not an active 4D case in Colorado. They just have the order. And so if payments were to come in there, because that's where the obligor was directed to pay, you would simply ask them to forward payments that they receive to you because you do have a 4D case open, and you'll be forwarding those monies onto the CP. And again, it might be a different scenario where people are, and you may send an intergovernmental referral for enforcement to another state or to Colorado at some point. But since the money's going to Colorado anyway, perhaps in a non-4D situation, you would simply want those payments to come to you for forwarding to the CP.
Okay, so that's where I'm not exactly asking for enforcement. Okay.
Right.
Okay, thank you.
Thank you. We're currently showing no questions. As a reminder, for questions or comments, press star 1, please.
Okay. Well, we do have another scenario we'd like to go through, and that may generate some more questions.
So before we do that, I do see that we have a question online.
Oh, okay.
And we do have a few questions on the phone again. Thank you.
Oh, great. Okay. Well, we'll take the one online. Did I hear that we do not have to include a copy of the responding state's order and pay history with the request any longer?
Good question, and no, you didn't hear that. What we're really focusing on the matrix is the federal forms, not the additional documents that you might want to include. So it is helpful to include. You don't have to include a copy of the responding state's order, but it's very helpful. And certainly if you have a pay history that does not involve the responding state, so you were getting payments or another state was getting payments or the obligee was getting payments directly, you would want to include that.
Right, and as you get comfortable with different states, you have a good relationship with them, then you'll know whether or not it's really best for you to provide the copy of their own order, or if that's not a situation, or as the previous questioner asked, if they were already enforcing it, they probably had a copy in their file. So sometimes just a little communication to make sure that they have what they need to proceed.
Also, I would encourage you, if you're a state that uses QUIC, to check QUIC before you take any action and see. That will tell you if they're currently enforcing the order. And if they are, as Bill said, then they're probably not going to need any additional except the transmittal number 1 and the confidential agency form.
Okay. So we have a question on the phone?
Yes, actually just one question. We have Martha Jewett. Your line is open, and please identify your state.
The state of Vermont is where I'm from, and I have a question in regards to the redirect. Along with the other woman that was on the phone, it says, E says change of person or entity entitled to receive the funds and enforce. So it's not just to enforce it. It would be, for example, if a person is on public assistance, we would want them to enforce it and send the funds to our office, not to the mom.
Right. No,
so
actually,
isn't that what we would use as a redirect, not just enforce?
No, if you're sending a transmittal number 1, you're asking them to send the payments to you regardless. But that E is for the child is now with a different obligee, and in some states, as a responding state, sometimes they'll actually create a separate case, so they have a case for each obligee. Sometimes it'll be combined into one case. Or it's also if the child goes into foster care in your state. So foster care becomes the new payee.
Okay.
So that's really a very specific, you've got a new obligee or the child went into foster care on E.
So it's change of custodial parent.
Yes.
Whether it be biological parent, guardian, or family services. Okay.
Right.
Thank
Correct. You. Mm-hmm.
Okay, if there are no further questions on that, we'll go through another scenario. In our next scenario, mom and child are in California. The alleged father is in Florida. The parents were never married and no acknowledgement of parentage was completed. Mom applies for 4D services in California. Since California has no basis for long-arm jurisdiction, the worker is preparing an intergovernmental action. What action should be requested on the transmittal number 1?
Again, take a moment and see if your answer is going to match mine. But this one's a little more complex. You're going to mark action 1 for establishment of paternity and 2A. And so that's going to also request establishment of support. If you're requesting establishment of any retroactive support, you'd also mark 2B. So you might have 3 things marked.
Thank you, Jeanette. What other federal forms must be included, or what federal forms must be included?
And again, if you look at your matrix, hopefully you'll have the response to this. And this one, there are actually 6 federal forms, so there are quite a few. The Child Support Enforcement Transmittal Number 1, initial request, of course, and that's what the responding agency is going to use to open their case, along with the Child Support Agency Confidential Information Form. You also need the Uniform Support Petition, the General Testimony, the Personal Information Form for UFSA 311, and the Declaration in Support of Establishing Parentage. And remember that if there's more than one child, that last form is required for each child.
Thank you, Jeanette. Are there other documents that should be included or would be helpful?
And on this one, there are probably going to be several. It's helpful to include a birth certificate or official birth record, and that's to ensure that there's not already a different parent's name listed, or that this parent isn't already listed and maybe paternity is not needed. Of course, supporting financial documents might be needed for the responding state's guidelines. Now, not all states use both parents' income, but I would make that presumption and send supporting financial documents.
Thank you, Jeanette. And we'd like to take questions on this scenario if there are any.
From the phone, for questions or comments anytime, it's *1, please.
And I don't have any questions on the Q&A at this time. Are there any questions on the telephone?
We actually have one that just came in queue. One moment, please.
Okay.
Thank you. We have Marcia Carlson. Your line is open, and please identify your state.
Minnesota. So I'm wondering in this scenario that if the child is receiving medical assistance as well, and we want to, now I see it says including medical support. That's what I was looking for. I'm sorry.
Right. You only mark the medical support only if in a case where the child's getting medical assistance and your state still requires you to open a 4D case, even though the obligee does not want 4D services. So that would be where you'd use the medical support only.
Got it. All right. Thank you.
You're welcome. If there are
no further questions from the phone.
Okay, if there are no further questions, we do have another scenario we'd like to go through. In scenario number 3, mom and 2 children live in Maine. Dad lives in Kentucky. A child support order was issued by Utah when the parents separated. Mom knows that Dad just received a promotion and is requesting a modification of the Utah order. Once again, we'll ask the same questions. What action should be requested on the transmittal number 1?
And again, take a look at your forms matrix or at the transmittal. In this scenario, though, before we can determine the appropriate action, we have to look at which state has continuing exclusive jurisdiction to modify, or called CEJ. Since none of the parties live in Utah, the non-requesting party state, Kentucky in this case, would do the review for modification. So on your transmittal, you would mark Action 4C, requesting enforcement and modification of the Utah order.
What federal forms must be included?
Similarly to the one we just looked at, there are 6 federal forms, but a little different. You still would include the Child Support Enforcement Transmittal Number 1 initial request, the Child Support Agency Confidential Information Form. You need to include the Letter of Transmittal requesting registration, the Uniform Support Petition, the General Testimony, and the Personal Information Form for UIFSA 311.
Are there other documents that should be included or would be helpful?
Well, UIFSA, of course, requires a certified copy of the Utah order. And, again, you should include payment records and supporting financial documents for the responding state to be able to run their guidelines.
Thank you, Jeanette. And we'd like to open the lines briefly again, or if there are any questions on that particular scenario.
Thank you again. For questions or comments from the phone, press star 1.
I do have a question online. It says, why would the 4D case be closed? Wouldn't Kentucky enforce?
You would not close your 4D case. That's why your request to Kentucky, because the obligor lives there, would be to register, modify, and enforce.
Right. Kentucky is the state of the non-requesting party.
So in that case, Maine has their case open for the custodial party, and then Kentucky opens the responding case. I do want to make one other comment on sort of related to this scenario, and that is that this is the only instance when you go to the non-requesting party state. Another error that we saw a lot was a state asking us to modify their own order even when a party still lived there, thinking that you always went to non-requesting party state. So non-requesting is only if no one lives there.
Right. Good point, Jeanette.
And I don't have a transmittal in front of me. They're indicating that maybe we have the wrong letters.
Right. 4B instead of 4C. Yeah, I don't have one in front of me either.
If 4B is the one that's enforce and modify, then you're absolutely correct.
Jeanette, this is Ann. 4B is take the following action on a support order of another jurisdiction and forward payment to the initiating jurisdiction's SBU, and B, register, modify, and enforce.
Okay, so we do have the wrong letters. I'm sorry about that. Thank you for catching that.
And we do have questions from the phone whenever you like to take those.
We're ready for those.
Thank you. We have Penny Dransfield. Your line is open, and please identify your state.
Wisconsin. My question is, when would it be appropriate to use 4C to close your intergovernmental case?
Well, the time we would have done that in Colorado is if the non-requesting party state is the obligee. So in other words, if it was the obligor who requested a mod and the mom state didn't have an open 4D case, all they're really going to do is modify. It's really not effective for them to do the enforcement because they don't have the obligor there. So that's a case where you might ask for register it,
review for modification at the obligor's request and then close.
All right, thank you. Does that answer your question?
Yes, thank you.
Okay, thank you. Next question, Vershawn Franks. Your line is open, and please identify your state.
Hi, I'm calling from Louisiana. I
Hello.
only wanted to get a listing of the forms that were needed again. I was trying to write them down in the sheet and it went kind of fast. Federal forms must be included. I got Transmittal 1, the confidential information form, the USP, the general testimony, and there were 2 other forms you said.
The letter of transmittal requesting registration and the personal information form for UFSA 311.
Okay.
Are those the 2 that you missed?
Okay, thanks.
And are those on the slide, Jeanette?
Well, they will be on the what we publish on the website.
Right. And the forms matrix hopefully will be available soon as well.
I was just about to ask if there was another matrix. Okay.
I'm going to let Ann answer when she thinks that, or Ann or Vet, when the forms matrix. You can certainly use this one. It's a draft form, but you can use it until we get the final one out.
Right, and it was sent out with the PowerPoint and with the web presentation information. Is that correct? The draft.
Hi, this is Ann at OCSE. We hope to publish that within 2 to 4 weeks, and it'll be on our website.
But the draft that you have that's on the slide, it would be, isn't it the very last row that we're talking about, Jeanette and Debbie? So if you do have it on the slides or on the handout, even though it's in draft, I believe we're talking about the final row. And that lists 6 documents there, and so hopefully you can look at that.
I see it. Thank you.
Thank you. Are there other questions?
We do have one more question. We have Eleanor Tate. Your line is open, and please identify your state.
South Carolina. You guys know me by now. Okay. I'm glad you brought this up because I have a question about the when we do this, and there are 3 states, quote unquote, involved. There is a form that we had on the last training, the Child Support Agency request for change of support payment location. Do we use this form before we go through all these steps that we just discussed? What?
Well, in this scenario, you're looking at a modification, so that form probably wouldn't be applicable. Once you send it to the responding jurisdiction to register, modify, and enforce, then that other form that you're referring to, I don't believe would be applicable.
So this change of support payment location, it's only if we're trying to determine if an order exists in another state? This form is
not exactly. You should be able to determine that through either FCR information or QUIC or perhaps a phone call or contact with the CP or NCP about orders that exist.
All right.
So that form in this scenario might, let's say Utah has a non-4D case. We assumed, remember at the beginning, we assumed in these scenarios that no payments were being made. But if the obligor were making payments through Utah, especially through a non-4D account, you might also send that to Utah so that you could start receiving the payments. Once, of course, Kentucky modifies or even begins to enforce, then the payments would be going through them. Okay. But that form is only sent to the order issuing state.
Okay.
All right, good point, Jeanette.
And we know there's confusion about that form because it's a very new concept.
It is, and I'm still trying to wrap my head around it. Is there a way, in order for me to sound like such a dodo head on this phone, is there a phone number I can call somebody and get one-on-one, because I'm so confused about that form. A lot of this I'm still trying to wrap my head around. and I just want to make sure that I am doing what I'm supposed to be doing.
Well, you can always reach out.
Why don't you give us your phone number, and we'll figure, does that work, Ann? We'll figure out who should maybe be in contact with her.
Yes, or you could send us an email at ocsegpt@acf.hhs.gov, and I believe it's on the last slide as well.
That's
and
right.
We'll be happy to help you out. I also want to draw your attention to, I think Debbie was going to mention this in a minute, but on our website, IM 1702 has the first 3 trainings on the forms, and the payment redirection provision under 319, the form, we trained on that in session 3, and it will be loaded on our website hopefully within a month. We have the first 2 form trainings on the website as right now, and session 3 will be up shortly.
Okay, I appreciate it. I'm sorry to have so many questions. It's just
that's okay. That's what we want. We want you to ask those questions when you have them.
Yes, thank you.
Thank you, guys. Thank you.
Yes, you're welcome. And we do have a question online about where will we be able to listen to the presentation recording. So I think Ann addressed that. They will be available on the OCSE website. I assume you go into the Intergovernmental page and locate them from there. I don't have the specific web address. But also, as Ann mentioned, there's a email address on the final slide that you can ask questions and submit questions. Do we have any other questions at this time?
We're showing no further questions from the phone.
Okay. We do have one online, Bill.
Well, I think that one is, in this scenario, would it also be appropriate to pick C if the custodial parent was only wanting the order modified because the initiating state is doing direct enforcement? And I think you sort of touched on that, Jeanette.
Yeah, my response to that would be if that's where the obligor lives, you should ask them to enforce and modify, not just modify.
Right. Okay.
Mm-hmm.
Very good. Okay. I would like to turn it over to Debbie to talk about effective date.
Thanks, Bill. You may be wondering when you must use these forms or when you might start receiving them. We know that some states have begun programming for these revised forms, so you might receive revised forms at any point if you haven't gotten them already. And they're valid now, so they can be used currently. The deadline for all states to begin using the revised forms is January 15th, 2018, and the delayed date is to give states time to program these changes. Until then, the old forms are still valid and should be honored. Okay, so Ann talked about resources. Here's the resources page that we have for you, and these are available on the OCSE website. And we included the links to them up here for you to be able to find them. The forms and the training sessions, as well as the forms matrix, which should be available soon, will also be out there. Okay, so let's wrap up the training. So we've covered a lot of material in these 4 training sessions. So to wrap up training, here's what we covered. So in session 1, we provided background on the revision process and why we went through what we did to make the changes to the forms. In session 1, we also discussed the general changes that were made across all of the forms. And in session 1 through session 4, we talked about in depth about the specific changes made to each of the 13 forms. In all of these sessions, we've talked about the effective dates for the forms, and in today's session, we've gave you some resources to reference. So now I'm going to turn it back over to Bill, and we're going to ask you if you have any further questions.
Thank you, Debbie. We have just a few minutes if there are any final questions before we wrap up.
Thank you again. For questions or comments from the phone, again, it's *1, please. Okay, thank you. From the phone, we do have a question from Marcy Hamilton. Your line is open.
Hi, I'm from the state of Oregon, and I was looking at the forms matrix, and it does not list the transmittal number 1 acknowledgement. And I was just curious if the initiating state is supposed to include that along with the initial request, or if that's only for the responding state to complete and return.
Great question. No, the initiating state no longer generates the acknowledgement. Since we divided it into a separate form, that will now be generated by the responding agency.
Yeah. Thank you.
Thanks, Jeanette.
Thank you again. As a reminder for questions from the phone, it's *1. We have next Lydia Monahan. Your line is open, and please identify your state.
Hi, I'm calling from Minnesota, and I have a question that's kind of technical. We have a very old document generation system, and there's limited lines for text. And we were wondering if it's possible that we can abbreviate words like AMT for amount instead of actually spelling the word out. Is that something that is possible for us to do, or would you prefer we have the entire word spelled out as is on the form?
This is Yvette Riddick, and as you know, these are OMB forms, and so we really don't have the authority to tell you that you can abbreviate the words. I'm sorry for that, but
that's okay. We kind of assumed that.
We have told states at times that provided that they keep the data elements in the proximity of where they are on the original form, and other states will find them quickly. They can change the font, but there's no change in the wording.
Okay, thank you so much for that clarification.
Thank you.
Thank you. And from the phone, we're showing no further questions.
Okay. And we are getting down on time, and I have no further questions in the Q&A section. So we would like to go to the last slide and remind you once again, you can submit additional questions, and remember that these slides and notes will be available soon on the OCSE website. And as the slide indicates, the web address for questions, ocse.dpt@acf.hhs.gov. Now I would like to turn it over to Yvette Riddick to wrap up our training sessions.
So I wanted to end the training session today because it is the last session of 4. And as you can imagine, there's been lots and lots and lots of work done with this. And I'm really happy that this product has been put together because it'll stay on our website for a long time. And for those of you who ask a lot of questions, we couldn't be happier because it's just going to help us to really, really clarify how interstate processing and intergovernmental processing in general will get better with automation and with clarification and with the revised forms and so forth. So we really do appreciate your input, and we really are here to support whatever you want to do. Interstate's been a problem in child support for a long time, and we really, really want to clean it up as much as we can. With that said, I have to really recognize Debbie Ward and Bill Meyer and Jeanette Savoy. Debbie, of course, has been working with us in the Division of Policy and Training for a while and has had a lot to do with the training work group that put the National Forms Revision Work Group. I can't remember the official name anymore, but anyway, she coordinated a lot of things about the forms when we revised them, and so I want to acknowledge her for that. Bill Meyer as well was part of that group. Bill has extensive state child support background from the state of Missouri before he became a federal employee and worked in interstate extensively, so we really appreciate his expertise. And then we have Jeanette Savoy, who works with us, and she also has very extensive intergovernmental expertise as managing the central registry in the state of Colorado. I've known her for many years. She's considered a national expert in interstate, so we are grateful to all 3 of you for putting on this webinar. So thank you very much from OCSE Central Office.
Thank you, Jeanette. We'd like to thank everyone for attending and for the great work that you do. And we hope that this was helpful for you with the forms training.
Thank you for your participation. That does conclude today's conference. You may disconnect at this time.